The next case before the court is Michael Martin et al. The Max Convenience Stores LLC. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. You should not use the names of children or any minors or victims. You can use initials or generic terms. And I assure you the judges have read your briefs and we are ready to proceed when you are. And as for the appellant, would you like to reserve time for rebuttal?
I would reserve 5 minutes.
Very good. Then we are ready to proceed when you are.
Thank you very much, Your Honor. Members, may it please the court, I am Alan Medvick. I am here on behalf of the appellants, Michael Martin and Anthony Brown. We are here on a sole issue. This matter was dismissed based on interpretation of the savings statute that the appellants disagree with based on the plain letter reading of that law. The matter was previously dismissed by notice under Civil 41A and refiled, and then subsequently a second dismissal by the court, specifically without prejudice, was made, and then subsequently the case was refiled. It's unquestioned and undisputed that the second refiling, third filing of the case was outside of the statute of limitations. It is the argument of the appellants that the savings statute preserves their right to file that third case. It's obviously the appellants disagree with that. As indicated in the briefs, and I'm not going to bog them down with stuff that I have already said, the plain language is clear and unequivocal that there's nothing restricting the second dismissal in any way in that. It is if there is a failure other than on the merits, the plaintiff may commence a new action within 1 year after the date of the reversal of the judgment, or the plaintiff's failure on the merits, or within the period of statute of limitations, whichever is later. That language is clear, and there's nothing in there that restricts the filing of the second appeal within that statute, that same statute, after that second filing and second dismissal. There is obviously case law that's been cited to by the appellees that under a prior version of the statute that support their position that you cannot avail, the plaintiff cannot avail themselves of the savings statute twice. I would contend that that language is not present and is a misreading of the current law. Most of those, in fact, all of the references to that rule predate the adoption of this amended statute, and I think that the language here is unequivocal.
Counsel, can you tell me whether what is the limit then on the application of the savings statute? How many times could you use it?
The reality is that limitation is, according to the record, it would be, according to this law, there is no limitation within that savings statute. But that does not mean that is an unlimited version of that statute. And with that, my concern would be that those are limits that are placed by your ability to, the court could limit that statute. The court does not have to grant that dismissal. The court does not have to allow that subsequent filing. Or in this case, we're still limited by the double dismissal rule under 41A1. And that's where I would point to is that there's Supreme Court case law regarding the double dismissal rule that I think is analogous here in Olinek v. Skoll. That is 2007 Ohio 2878 that made similar determinations regarding the extent of the double dismissal rule. And and that is such that those dismissals, by the plain language of the rule, have to be notice dismissals. Both of them would have to be under 41A1, whether that's a failure of service or 41A2 dismissal. Those failures on the merit do not implicate the double dismissal, and therefore the court has held that you can file a third time in those instances. And I would say that this is analogous to those statutes, to that rule and that analysis. And that is under the current version of 41. And post this decision, this amendment to the savings statute, 230519.
So is it your argument that the amendment changed the way that, under the old version, that you would not have been able to file again?
I would argue that the limitations contained in that prior statute gave some rise to the concern and the refusal to apply the savings statute a second time. And I think that the amendments to the statute took out the language that would have given rise to that. Yeah. And that specifically being the elimination of language regarding filings after the failure of the statute, after the expiration of the statute of limitation. The amendments were to address a concern about when the savings statute was applied. You could not previously dismiss a case within the savings statute and avail within the statute of limitations and avail yourself of the extra time under the savings statute. If you filed it a day before the end of the statute of limitations, you'd have to refile a case the next day and not avail yourself of the statute of limitations. That was corrected. And I think that was to correct an error that regarding that language, and that this language could have been addressed and could have been at that time specifically stated, and it's not there. And so that is my position. Thank you.
Thank you very much.
If there's nothing else, I'll see you.
Okay, you will have your full 5 minutes for rebuttal.
Thank you.
Good morning. May it please the court. Counsel, Judge Lansinger, it's a pleasure to argue in front of you for the first time. Hopefully it won't be a memorable experience for you. My name is Brian Sullivan. I have the pleasure of representing the defendants, Max Convenience Store, doing business as Circle K, in this appeal. And I urge the courts to affirm the trial court's dismissal of the third refiling of plaintiff's complaint, a complaint that was filed more than 7 years after the expiration of the statute of limitations, and after the plaintiff had previously used the savings statute to save an untimely second filing of the lawsuit. As counsel mentioned, really the limited issue before this court is whether Ohio savings statute, revised code section 2305.19, can be used more than once to save an untimely lawsuit. The facts of the case are, this is a motor vehicle accident. The plaintiff was rope towing a vehicle behind them. They were traveling under 30 miles an hour on the interstate and were rear-ended by my client. Almost two years to the day, 1 day prior to the expiration of the statute of limitations, plaintiff filed their initial lawsuit. It was ultimately dismissed by way of a notice of voluntary dismissal without prejudice because there was a pending motion to dismiss the lawsuit for failure to prosecute. A second lawsuit was commenced. It's undisputed that the filing of the second lawsuit was after the expiration of the statute of limitations. As a consequence, it was necessary for the plaintiff to utilize the provisions of the savings statute in order to permit him to refile that lawsuit. Ultimately, the plaintiff moved to dismiss the second lawsuit because he was unable to produce expert reports in a timely fashion. The court granted that motion and dismissed it without prejudice, which then ultimately resulted in the filing of the third lawsuit, as I mentioned, approximately 7 years after the statute of limitations had expired. The trial court reviewed the defendant's motion for judgment on the pleadings and/or a motion for summary judgment that was presented to it. In support of that motion, the defendant submitted the dockets and some of the pleadings from the prior litigation to demonstrate that it had previously been refiled and then the plaintiff had previously utilized the savings statute. The defendants also cited Supreme Court precedent, the Thomas versus Freeman case, as well as authority from this court, the Wick versus Lorraine Manor case, which had conclusively established that a savings statute could only be utilized once to refile an untimely action. As a consequence, the trial court granted the defendant's motion for judgment on the pleadings and over summary judgment, which leads us here today. Now, the plaintiff's argument, I think, is really reduced to two separate contentions. One is that the savings statute, that the foundation for the case authority that supports the proposition that the savings statute can only be used once originated from a version of the statute that existed prior to 2004. And their contention is that the statute was amended in 2004 to have more liberal application, and as a consequence, the authority that interpreted the prior statutes of questionable vitality. That argument has been rejected uniformly by the appellate districts of this state, including this court's decision in the Wick versus Lorraine Manor case, which was decided in 2014. The amendments to the statute were in 2004. And the Wick case analyzed the revised statute, and in so doing said that a plaintiff can employ the savings statute if they satisfy two elements. One, the commencement of an action before the statute of limitations has expired, and two, the failure otherwise than upon the merits. In this case, it's undisputed that the second lawsuit that plaintiff filed was not commenced within the statute of limitations. So they have failed that element of the analysis. I would also point out that according to my research, I believe every appellate district has reviewed the amended statute since 2004 and come to the conclusion that the savings statute cannot be utilized more than once to save an action. The second prong of plaintiff's argument is that the text of the statute itself does not contain language that says it can only be used once. This argument has also been rejected by every appellate court that I have found that has considered the issue. Most recently, it was rejected by the Second District Court of Appeals in the McCullough case, which, as a side note, and in the interest of candor, I would tell the court that I just learned yesterday as I was preparing for the oral argument that the Supreme Court has accepted the McCullough case for review, and it's currently up before the Supreme Court. The issues that McCullough presents are separate and distinct from the issues here. I don't think the outcome of McCullough dictates the outcome here. But in any event, the Second District in McCullough addressed head-on the contention that the statute should be interpreted in such a way that it's essentially could be utilized in an unlimited fashion, and rebutted the argument that because the statute itself doesn't contain language that says that it can only be applied once, that it should be able to be applied multiple times. And in so doing, the court concluded that the foundation of the statute presupposes that the prior action was filed within the statute of limitation, which is exactly what this court observed in the Wick versus Lorraine Manor case. And they said, with that foundation, with that understanding of the foundation, it's patently clear that the saving statute can only be used once. Otherwise, it would completely frustrate the purpose, and it could presumably be used indefinitely to save untimely filed actions. Now, Judge Sutton, in response to your question, plaintiff indicated that while his interpretation of the statute would lead him to believe that it could be used unlimitedly, there were other safeguards in the system that could presumably prevent the plaintiff from constantly refiling actions. And that's true, but it ignores the reality of the statute and the application and the purpose behind the statute. And that purpose has been set forth in Supreme Court precedent, again, the Thomas versus Freeman case, in a plethora of cases decided by all of the other appellate districts in the state, which have indicated that the purpose of the statute is to prevent serial refiling of untimely lawsuits. The plaintiffs who avail themselves to a voluntary dismissal or who obtain a dismissal otherwise on the merits have, one by have one bite of the apple. They have one opportunity to refile that action within 1 year of the dismissal. And if they do, then their action is saved and they can proceed and is not time barred. But the statute does not contemplate a circumstance by which they can continually refile and refile and refile in an attempt to utilize the protections of the saving statute to protect the timeliness of their suit. So for those reasons and the reasons set forth in the brief, we would urge the court to affirm the judgment of the trial court below.
Thank you very much, Counsel.
Let me brief in a moment. I would indicate that the language in Thomas v. Freeman is indicating my brief is dicta in that case and is not binding, I'm not sure. It has been latched onto by other courts, including this one, I will acknowledge, as a basis for this position. But if you read Thomas v. Freeman, there is nothing in that court that decides at the Supreme Court level that you cannot file a case twice, use the saving statute twice. I would point to the words, the Appellee's Counsel used the term, ignores the reality, and then went on to talk about a bunch of things that are not actually indicated in the statute, including the patent underpinning of the purpose of the statute, or that the intent was that the saving statute only be used once, and that the quote, purpose of the statute is to prevent serial refiling. I would argue that the purpose of the statute, as articulated, is to allow for refiling of cases. That is what is articulated there. That is the patent underpinning is to allow persons and plaintiffs who are in the process of working on cases to refile those actions. There is nothing in that language that states or that demonstrates that is intended to limit the refiling of those cases. It is in fact intended to provide an avenue for the refiling of cases. The serial refiling of cases is limited by the statute of limitations, by the saving statute itself, and having a time limit, by court's ability to not allow dismissals multiple times, by the double dismissal. All of those are things that limit serial refiling. The saving statute, by its plain language, is the exact opposite of that and allows for the refiling of cases. So with that, I would recommend. Thank you.
Thank you very much. Thank you both for your presentation. The court will take the matter under advisement and issue a decision in due course. That decision will be mailed to you by the clerk of courts on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Again, thank you very much for your presentation.
Thank you.